Mr. Chair, you're now live.
Thank you. Good evening, everyone. Welcome to the City of Annapolis Board of Appeals regular virtual meeting for June 1st, 2021. This meeting is being broadcast on the city's YouTube channel. My name is Bob Galler, Chair of the Board. This virtual format allows the public to observe the meeting through the video link and to submit written comments through the City of Annapolis website. Links to the YouTube channel and the comment form on the city's website and the case database for information related to the cases you'll hear about tonight. All those links may be found on the agenda for tonight's meeting. The people you see on the screen are members of the Board of Appeals. When a case is called, representatives of the parties to the case will also appear on the screen. Also participating in the meeting are counsel to the Board of Appeals, Cheryl Woods, our recording secretary, Tammy Hook. Our technician tonight is Julian. And participating also, we may have various representatives of the city, including Dr. Sally Nash, Director of Planning and Zoning, Joelle Braithwaite, Assistant City Attorney and Counsel of the Department of Planning and Zoning, Jacqueline Rouse, Liaison to the Board, and Cynthia Gudenius tonight from the planning staff. We ask everyone but members of the board to mute their audio. If anyone wishes to speak during the meeting, please raise your hand and I'll recognize you to speak. Written comments on matters that come before the board tonight that were submitted up until noon today are made part of the record and have been forwarded to the members of the board and to the parties. In order to allow additional comments in response to matters that arise during hearings tonight, the record in those cases will remain open until the next meeting on June 16th. So comments submitted up until noon on June 16th will be made part of the record as well. Let's see. Let me remind everyone that communications with the board about any case by anyone other than a party to the case must go through the comment form. All communications by parties must go through the board liaison, Jackie Rouse. No one should contact any member of the board directly. So we'll begin the meeting with call the roll. I'll ask Tammy Hook to do that, please.
Mr. Gallagher,
Yes.
Mr. Dews,
Present.
Dr. Chen,
Present.
Mr. Zazali,
Here.
Mr. Walsh.
Present.
Wonderful. We've got 5 members of the board, which is more than a quorum. Have the members of the board had a chance to review the agenda for this evening's meeting? Do we have any corrections or suggestions for changes? If not, I'd entertain a motion to approve the agenda.
I move that the agenda be approved as written.
Second,
Second.
all in favor?
Aye.
Aye.
Thank you. Now we'll turn to minutes. We have minutes from the meeting, the last meeting of May 19th. Any corrections or additions to the minutes? May I have a motion to approve the minutes?
So moved.
Oh, second.
All in favor?
Aye.
Great, thank you. So we've got a busy agenda tonight, 5 different matters to come before us. The first one is continued from last week. It was Variance 2021-003. If Julian would like to bring in the parties to that. It's the application for a variance to allow reduction of the Waterway yard setback at 1001 Moss Haven Court. You'll recall this is about replacing in-kind retaining wall and stairs that have sagged and failed over the years. So I think we were all present for the evidence on that last time. Have there been any additional public comments?
No, Bob, there have not been any additional public comments. We never received any before the presentation last on the May 19th hearing, and we haven't received any as of noon today.
Okay. In response to my questions about the right-of-way last week, I saw a letter from the Department of Public Works discussing the ownership of the right-of-way. We're not going to include that in the record. The board doesn't decide ownership issues, and it's really not pertinent to whether we grant this variance or not. So and no one had a chance to cross-examine or anything, so we'll exclude that. We don't need it. So the record in the case is closed, and we'll proceed with deliberations. Let me ask Christian if he would mind starting on this one. You're on mute, Christian.
I think this is a fairly traditional example of boundary lines being established and critical areas being established prior to the property through no fault of the owners. They've purchased a property that is in dire need of stabilization and maintenance. Because of the way the codes are structured now, they need these variances to affect that maintenance. And for those reasons, I think should we go to a vote, mine will be to make a motion to approve this request.
Who else would like to be heard on that?
Chairman, I agree with Kristen. I think the property itself is unique. Familiar with that street and the other lots on that street. This lot clearly is different in the way it's proposed, and also agree with Kristen that the obvious slope needs remediation, as does the structures leading to the water. So I would also approve this.
Rob, you said you had nothing?
No, I don't have anything. I concur with the opinions of both of which were expressed.
Dr. Chan?
I agree.
Okay, so
I agree that that certainly most of the requirements for a variance have been met. The one that concerns me, I think I alluded to last week, and that is the public welfare. The record is clear that there's a public right-of-way that runs along the property there. There will be minor disturbance in completing the project on the right-of-way. That's not very troublesome. But it looks like a prior owner has intruded into the right-of-way, building a retaining wall, and that may well have been necessary, but it may have improved the stability of that part of the right-of-way, but nevertheless, it's an intrusion. So whether or not that right-of-way extends to the water, and that seems to be a question, because it is a public right-of-way and there's already been some intrusion into it, my suggestion was that we have a condition that the owners won't do anything to interfere or discourage the lawful use of the public right-of-way. I asked for a comment from the owners on that. I haven't heard one. But I think that's something that we have the power to do, members of the board, to include that kind of a condition. I wonder if any of you have anything you'd like to add on that subject.
no, it's consistent with, oh, sorry, go ahead.
I agree with you, Mr. Chairman. I would support a condition of that type.
Yeah, that's a condition that's consistent with what we applied to the recent restaurant at in Ego Alley.
Yep.
We're not imposing any penalty or any condition that doesn't exist. We're just asking them to acknowledge and honor it. That's all.
Whatever, I mean, the rights, the public's rights might
Whatever
be
they
disputed, but they have to honor them whatever they are.
Right.
Dr. Chan, any thoughts?
I agree.
So I would suggest a motion to approve the variance for the reasons that we find that all the requirements have been satisfied based on the evidence provided at the hearing and the matters set forth in the staff report and its attachments, with the condition that the owners or occupants will do nothing to interfere with or discourage the lawful use by the public of the public right of way. So would someone like to make that motion?
So
Well,
moved.
you so
Second.
eloquently taking the words right out of my mouth.
I second.
All in favor?
Aye.
Aye, thank you. All right, moving right along. And thank you, Leo and all the others who put that together. Nice job. The second item on the agenda, is that the, oh no, we're deliberating the
The remand.
remand, right? How could I have forgotten that? Okay, here we go.
Bob, before you can I ask a law question?
Yeah,
I did not vote on the original special exception or variance, but I've heard all of the subsequent.
yes, that's fine, because it's just the appeal where we look to.
I just
sure
wanted
you've
to
been-
get that clear.
Yeah.
Yep, thanks.
So Julian, I see you're bringing in the parties to special exception 2018-003.
So Bob, we're done with the variance at this point, and those applicants can be excused.
Excused, yes, I'm sorry, thank you.
Okay, great.
We're all very familiar with this case. This is the one where the circuit court has remanded to us for explanation how it was that we approved the special exception, but denied the variance that would have allowed sufficient parking for 75 cars. Did we have any comments come in on this since the last meeting? Anyone know?
No comments, no,
Jackie? Okay,
no
great.
comments.
So again, the record is closed. So the explanation that I offer is that what we do and what Department of Planning and Zoning does is very complicated. You have to get layers of approvals. Obviously, in this case, they need 3 separate approvals just from us, with many subparts we have to look at and address for each of those approvals. And there's very little guidance in the code about what you have to do first, what order you do things in. But it is clear in the code that in granting special exceptions, we can grant them conditionally. And we've always done that, as Christian pointed out, in almost every special exception we've granted. We have had conditions. And it's hard for me to imagine how this process would continue if we weren't able to do that. If someone would have to figure out what the specific order is, you've got to do everything to get this all done. So when we approved the special exception, I believe what we approved is the use of a restaurant with a number of seats that could be supported by compliance with the parking rules. And I think that's the only reasonable interpretation of the code that lets planning and zoning and lets us administer these complicated and overlapping provisions. I understand the citizens' concern and I understand their argument, but I think it's a strained and formalistic argument. I'm not sure it always works to the advantage of citizens who are challenging a decision by planning and zoning anyway. So my suggestion would be that we enter a written decision along those lines, explaining the basis that we had for the decision and the lack of inconsistency in our minds with the decision to grant a special exception and deny the variances. Looking forward to hearing from each of you.
Mr. Chairman, I'll start off. Give Christian a break. I do
Thank
agree
you.
with you. I do agree with you. I thank the rest of the board at the last meeting for asking the key questions. Andrew's not here tonight, but I thought his questions were very much on point. I did not hear anything in the testimony from our last meeting that indicated to me or persuaded me that the board does not have the ability to take the action that we did with the special exception. I also believe that the explanation you just provided is consistent with the circuit court's request for an explanation. So I agree with your comments.
Who else?
I think, the way that you've explained it is my recollection of how we approached the issue. It's my recollection from the discussion at the hearing 2 weeks ago that I asked counsel for the citizens that, I do recall that the variance was not approved and that the special exception was after the variance was disapproved. So we placed those conditions, a rather substantial number of conditions, in the special exception, and the sequencing is important that it occurred after the variance. So at least certainly I have great confidence and knowledge of my colleagues on the board that we entered into that special exception with the full understanding that the variance was not in operation. So I think you're right. To try to make it so rigid and formalistic would more or less render the process almost unworkable. And I think that the opting to give some deference to the planning and zoning department and the director's decision in terms of sequencing these items and our decision there that followed that is proper and appropriate. I read the decision from the court as basically saying, okay, just, you acted appropriately, you used you were on the record, you had substantial evidence to back up your position. Just explain to me how this works. And I think that the way you described it, Mr. Chairman, is a reasonable way to explain how we entered the process and came up with our results.
Rob, Christian?
I will add one thought because I did not vote on the other one, but I will say that I heard no evidence or testimony that led me to believe that the board did not move along those lines. And that while the variance and special exceptions do overlap and weave and rely on each other in many instances, they are not they're not inseparable, right? And the board has, by this deliberation and in the eventual opinion, will choose to separate the two clearly, bifurcate the two decisions. We as a board decided that the use as a restaurant shall be permitted with the special exception. The parking is another matter, and they were brought to us as a combined matter, but they are not a combined decision. They're independent decisions, and we have found that the special exception use is correct and proper. Now the parking can go on its own separate life.
Good point. Anything, Rob?
That was very helpful when you explained. I had to go back and read some of the history on this one because I wasn't up to speed on it. But it was helpful what you just explained. And in addition to what I did hear in the last month, that it just kind of convoluted the process to kind of to where trying to make where it didn't make sense. But now hearing the feedback from other members and kind of how the process flowed, certainly makes sense to have had the special exception and how those separate entities were approved. It makes sense now. So I didn't hear anything that would put doubt in my mind that it was done. It made sense how it was done.
It's it's complicated enough. I'll draft something up and send it out, make sure everyone's comfortable with it. If so, shall we have a motion to draft and circulate for signature a response to the circuit court explaining the basis for our decision?
Are we voting to uphold our decision to approve the special exception? Is that what we're?
In effect, but we haven't been asked to do that. We've just been asked to explain. Now, we file the explanation. I think if the protestants would like to, they can go back to the court and say it was an insufficient explanation. If they don't do that, then I think the special exception is in effect.
Do you think calling for a vote serves any formal purpose?
Only to show the extent to which the board supports, what is it, unanimous or less than unanimous, supports the explanation.
Okay, I support taking a vote, just getting it on the record as a clean up down.
All right, so someone like to make the motion that I suggested?
Um,
Go ahead.
Yeah. So the motion is to sustain the approval of the special exception with a clarification to the whoever.
I would make it, the motion is that we will enter a decision explaining the previous
Okay,
decision.
got it. So strike that last bit.
Yeah.
I recommend a motion to authorize Bob on behalf of the board to issue an explanation supporting our decision to reaffirm the approval of the special exception independent of the parking decision.
Second,
I'll second that.
all in favor?
Aye.
Aye.
Thank you. All right. Thank you all very much. Thank you, protestants, and Mr. Nelson and Mr. Christoph and your clients. We'll get to the end of this one of these days.
We always do.
Okay. So next item is approval of our draft revisions to the board's rules of procedure. By their terms, they become effective June 29th. And that was a date that I picked to try to honor the intent behind our own procedural rules relating to amendments and the new rules that don't technically affect us, but that's the timing there. And we need to approve them tonight if we're going to approve them. Otherwise, that timing starts to unravel. So you've all had them for a long time. We haven't had any real public comments. We did have feedback from some of you. We had feedback from the Office of Law. We had feedback from a couple of the council members. And so as far as I know, we're not doing anything that's going to annoy anybody. And I welcome a motion to approve the draft revision of the rules.
Well, since my microphone's on, I move that I move adoption of the proposed rules of procedure.
Right. Is there a second?
Second.
All in favor?
Aye.
Aye.
All right.
Aye.
Moving right along. Now we have,
That lacked a certain enthusiasm. I want to get on the record.
well, then you can write the next round.
They are excellent amendments.
There we go.
Just nominated
Because
himself.
my microphone was on.
Christian nominated himself to write the next round.
Okay.
All right, Julian.
See me.
Special exception 2021-003 relating to a proposed delicatessen at 82 Maryland Avenue. I hope this one works out better than the last delicatessen. All of you won't have been around to remember that one. Anyone who expects to give evidence on this matter tonight, I'd ask you to raise a hand, any hand you like. And do you swear or affirm, subject to penalties for perjury, that the evidence you will give tonight will be true to the best of your knowledge?
Yes.
No one? Someone? So,
Yes.
Lisa Ryan, great. Okay, Cynthia, you're gonna tell us what this is about, or is this Jackie's?
Mine.
Okay,
So the Ms. Ryan currently operates a business which you all previously approved at 90 Maryland Avenue as a food service mart, where she sells her prepared drinks and food items, as well as some non-related food items, retail goods, etc. And it's a very small space. It's 330 square feet, and she's now found another space on Maryland Avenue, which is a slightly larger space at 82 Maryland Avenue, where she wants to relocate her business to, so that she can add a food preparation area to the business and some seating. So that slightly changes her category. Her category, because when you have seating and you have a kitchen, then you move to becoming what is called a delicatessen. And so she has submitted an application which we sent out for agency review to move her business there. And it's a larger space. It's 820 square feet. We reviewed the application, sent it out for agency review. She will have some building and fire code and health department comments that will have to be complied with, as is true with all food service businesses, when she goes through the building permit review process. But she meets the standards for a special exception, and we're recommending approval of the application.
okay. With the applicant, is there anything you'd like to tell us that hasn't been covered in the staff report that you think is important?
You know what? I don't think so, because it's really thorough. We're just excited to, we've been at the 90 Maryland Avenue space for about 3 years now. Very successful. We actually survived and thrived during COVID. So that was really exciting, and the community is really excited about our move to 82. So we're really excited about that. So I'm very happy to have your support. So I'm excited about that.
That's the space that was City.Coffee.
Yep.
Yeah, great. Jacqueline, did we get any comments?
We did not receive any public comments on the application.
And you're satisfied that the notice and publication requirements have been met?
Yes, she's met all the publication and notification requirements. The property was posted. Businesses and residents in the area were notified. The community associations were notified, and the alderwoman of the ward was notified. I actually did have a call from the alderwoman of the ward, and she did verbally express to me her support for the relocation of the business.
I just got done saying a few minutes ago that all of our special exceptions have conditions. I didn't notice any in the staff report.
They're on page 3.
Okay, I missed them.
I think I responded to your email. They're on the 3rd page.
Okay.
They're not at the end. They're. So that was something that I did to make sure that you were actually reading the staff reports. I relocated the condition.
Jackie, I did read the staff report. I noticed that you're granting more hours than they asked for. Explanation
Yeah,
for that?
let me just explain. So she asked for very limited hours, but we did recommend and these are the same hours that we actually, I believe, recommended with her prior special exception till 9 p.m., 7 days per week. Although she is asking, because we felt like, we should afford her the opportunity for some flexibility in operation. And this would be consistent, I think, with recommendations we've previously made also for Annabeth when they went through special exception. You know, maybe she won't want to be open every night, but there may be times when she wants to, for special occasions, be open a little bit later. We wouldn't want to limit her. She's already proved to be a success and expanded, so let's give her a little bit more flexibility.
So for example, during December, when they're doing the bright lights or the special, I understand. Okay, thank you.
Events like that, yes, while still not being detrimental to, you know, there are residential uses in you know, around there. So we felt, and the 9 p.m. that's primarily, with one or two exceptions, more of a retail kind of street. So we, you know, we felt like this was, you know, she doesn't have to stay up until 9 p.m., but she'd have the opportunity. Christmas time, during the holidays, etc.
Jackie, any conditions or restrictions imposed on the special exception that unique to this application?
Do I think there are any unique to the application? Well, the
No, no,
hours.
any restrictions or conditions? Sometimes we see trash conditions or no
There is
smell.
trash. There's a trash condition. There are actually on page 3 of the staff report. There are 9 conditions, and they're the standard conditions that we apply to food service businesses pretty much.
Okay, so nothing unique, no unique restrictions or conditions.
There are no additional conditions other than the standard food service conditions.
Okay. Has Ms. Ryan, have you reviewed these conditions and you're amenable to them? Do you agree
I'm
with them?
sorry, I did
You
not
okay
hear.
with them? You've read all these additional conditions and restrictions with your application and you're okay with them?
Yes, I am.
Okay. We just ask that of everybody to acknowledge on the record that they've seen these conditions. They don't get surprised later.
Okay, yep.
More questions from the board?
I have a quick one. Jackie, in your staff report under traffic impact, you talk about it's difficult to assign the parking impact. Can you just elaborate for clarity?
So with businesses downtown, none of the businesses in the downtown area, Maryland Avenue, Main Street, are required to provide any parking. So all of their business is people walking to and from their business, to and from the location. So there would not be any way to determine how much what the traffic impact would be from a specific business. You know, Maryland Avenue, that is a shopping street, but there may be people who come to her business just because they want to have a beverage, but there may be other people who come or there may be people from the offices around there. So it's almost impossible to ever assign traffic impacts when you have an area like the downtown.
Ms. Ryan, can you maybe just tell us the 3 years you've been in business, what kind of customers you're seeing, foot traffic, and so on?
So the customers are mainly locals. So they kind of walk to my shop. So there's not a lot of parking issues or traffic or anything like that. Also, the second type of customer I have is a tourist who are also walking. They're not really driving per se or trying to find parking or parking care. The third type of customer I have are deliveries. So that would be where they're not even coming downtown, but unfortunately COVID kind of pivoted us to that. So hopefully we'll have, obviously our tourists back in town and things like that soon. So, but yeah, those are the 3 types of clients I have.
Thank you.
Mhm.
Okay, if there are no more questions, we will continue the hearing until June 16th, when we will make a decision.
Okay, wonderful.
Sorry it takes that long, but under the virtual meeting procedure, we have to have that lag. And it used to be a month between meetings, but we've compressed it to try to deal with that. So you don't have to wait quite as long. So thank you very much for your contribution to our vibrant local downtown scene. And,
Here, here.
Oh, thank you so much, everyone.
And we'll see you on the 16th. Thank you. All right.
And we need to put the exhibits in the record.
Yes, Tammy, great. I think everything is an attachment to the staff report, right?
It's C1, and then there's C2 is the application, and then C3 is the floor plan.
Okay,
Thank you.
that's great. Thanks, Tammy.
Mhm.
All right, we'll excuse the applicant and we'll move on. Julian, if you'd like to bring in the folks for Appeal 2020-04. We all here? Tony, are you there? I see we have Mr. Nelson. How about Mr. Christel? Is he?
I think I should be on, at least I'm not muted at this point. I don't see my face.
Okay. And we've got Joelle. Great. So as everyone will recall, this is another appeal by neighbors at 424 of the director's decision approving a minor site design modification that would allow the restaurant that we just dealt with in special exception 2018-003 at 424, 428 4th Street to operate with fewer seats, about 65 seats. Any additional public comments on this? Jackie?
No, we had no public comments.
Okay. So here's what I would like to do. This is pretty complicated, and Mr. Nelson has described in his brief, and I thank you all for the briefs that you've submitted now several weeks ago, the 5 issues that he believes are presented. And I think they're pretty much the same that the other parties have addressed, but just in a different combination. So what I'd like to do is address the issues one at a time. And the order will be the order we've used before. We'll have the appellants, the applicants, the city, and rebuttal by the appellants if necessary. So the first issue then was whether the applicants can get a minor modification based on the claim that the board denied the original site design plan. So Mr. Nelson, if you'd like to lead off.
Thank you, Mr. Chairman. Can the board hear me adequately?
Yes.
Thank you. Good evening. With regard to the first question about the threshold question about whether the applicant is even eligible for minor modification, let me just touch on something that we all know, which is that the board approved a special exception. It approved a zoning boundary adjustment, and the board disapproved the requested variances. The applicant applied for the modified plan, and DPZ approved that application in August. My client's appeal. Our legal position, if it please the board, is that the applicant has submitted his application in accordance with section 21-22.110, which is labeled modification of approved plans. And then it goes on, the text of the ordinance describes where the circumstances in which an approved site design plan may be modified. Our position here at the outset in this appeal is that because the board disapproved the variances, there was not an approved site design plan. And because there was no approved site design, the applicant was not eligible to file a modification of that unapproved plan. The applicant's remedy is to submit a new plan and start at the beginning. You can't modify, we assert, a plan that was never approved. So for all those reasons, we ask the board to reverse the DPZ's approval of the minor modification and require the applicant to resubmit a plan because they're not eligible to modify the unapproved plan. Thank you.
Okay, so Mr. Christoph, you agree that the board, that the site design plan was invalidated or denied by the board? Did we lose Tony? Oh, there he is. You're muted, Tony.
Now I'm hitting on all fours now.
All right, I got you.
I'd like to remind the board that the site development plan approval process is not by the Board of Appeals, but by the Director of Planning and Zoning. In this case, it was approved by the Department of Planning and Zoning and conditions were imposed. And one of those was it was contingent on approval of the ZBDA and also the variance. But section 2122-110A3 says that approved site design plans may be modified as follows. Note, note that it does not say fully approved or finally approved. And in fact, subsection 3 of that section makes no sense unless a modification can be to a condition imposed on a site design plan approval. Specifically, any request for modification of any condition imposed in a site design plan approval, which is deemed by the Planning and Zoning Director to be a minor modification. So clearly you don't have to have a final, a conditionally approved plan is still a finally approved plan, contrary to what the protestants contend. And as you've already noted in your deliberations or your vote on the remand, the board's opinion clearly left open and anticipated that there would be authorized changes to the approved plans. And I'm referring to paragraph 17 on page 9 of the board's opinion. Because, as has been determined by Planning and Zoning, the modified site development plan no longer requires the variances, the director deemed the modification request to be minor because it reduced the number of seats from 75 to 65 and obviated the need for any variances. So the process, in fact, has been correctly followed in the position of the applicants because it's authorized by code. There's no requirement for resubmittal of the site development plan if the variances are no longer required.
Okay.
That third subparagraph, as I've indicated, makes no sense unless you can have a conditioned site design plan approval, which is the case here.
Mr. Braithwaite, any thoughts on this subject?
Well, from the on the record review, we're looking at a action taken by the Director of Planning and Zoning, which on the record we presume is correct, and we presume that the director is accurate as to the facts she selected, and we also assume that the director is accurate as to the law she chose to apply to the particular application. With that in mind, absent a showing of clear error by any of these the appellants, I do believe that you must abide by the director's decision in not only approving but also recommending that that's the process that it take. And I think that the directors do deference with respect to her interpretation of the law. So if the director, by taking the action, perceives that the action is appropriate, unless it's a clear error, I do believe that you must hold the director's decision.
Okay. Do we have any questions from the members of the board for any of our distinguished counsel? Christian?
For city council, can you state on the record, one way or another, does the city agree that the site design plan was conditionally approved?
Yes, we do believe that the conditions that was attached are conditional. But I mean, I'm sorry to speak in such an axiomatic way. Thank you.
Nope, it was a yes, no question, and you answered it. Thank you. That was my only question.
Mr. Nelson, do you feel compelled to add anything to that?
Yes, I do. The plan was not approved. The applicant was not permitted to go forward with the plan because the variance was disapproved, and that ruling was affirmed by the circuit court. But in terms of the city's argument with respect to deference to the DPZ, I respectfully disagree. Fundamental principles of how you interpret an ordinance or statute are you have to apply the words as they appear on the paper. And there is no ambiguity. The title to section 21.22.110 is labeled modification of an approved plan. And the text speaks to approved site plans are eligible to be modified. This plan was not approved. The applicant was not permitted to proceed with the development after the board's ruling. So for all those reasons, I respectfully urge the board to reverse the decision of the Department of Planning and Zoning. Thank you.
All right, let's move on to the second issue. We'll come back to you, Mr. Nelson. The 9 parking spaces.
Right. You know, we all have lived this case, but I think Mr. Christoph and I have probably lived it more closely than the board. So let me just.
Let me interrupt you. I've asked Julian if he could screen share the drawing that shows us the parking places that you're
Thank you very much. Okay, that's very helpful. So what we're talking about are the 9 parking spaces on what we call the north boundary of the property, which is the upper section of the page. And those 9 parking spaces are beneath the building at 424 4th Street. And the board will recall that the applicant in 2018 applied for a variance for permission to have those 9 parking spaces. The board will recall that the staff report summarized that request for those variances for the 9 parking spaces. The board expressly addressed the variance request for those 9 parking spaces and disapproved the variances for the 9 parking spaces, among other variances. Then the circuit court affirmed that ruling. Our fundamental premise here is the law of the case is the applicant applied for a variance for these 9 parking spaces. The board disapproved the variance and the circuit court affirmed that ruling, and the applicant did not appeal. So that's the law of the case. So now the question is, with the applicant has come forward with a modified plan, and the premise of the modified plan is as if that history, which I just recited the board, never occurred. The premise of the modified plan is they never sought a variance, staff never addressed the variance, the board never disapproved the variances, and we never went to the circuit court. They presented this plan as if none of that history occurred. And we respectfully suggest that that's inappropriate. But let me just talk about the threshold legal question. What is the setback requirement for these parking spaces, these 9 parking spaces? And the board will recall that on the other side of the property line is 418 4th Street. On the west side is where my clients reside. So the relevant ordinance that sets forth the setback requirements appears at 21.62.120 paragraph G. And if we go to that section of the ordinance, my clients, I on behalf of my clients, direct the board to one section there where there's a 20-foot setback. and my adversary, Mr. Christoph, directs the board to another section with a 10-foot setback. And what it says is that a parking lot adjacent to residential property with 16 or more spaces has a 20-foot setback. Here, the proposed setback is 10 feet, not 20. That's the provision of the ordinance on which my clients relied. Mr. Christoph, on behalf of the applicant, relies on another section which says that a parking lot that's adjacent to sites in non-residential zoning districts has a 10-foot setback. So Mr. Christoph argues for a 10-foot setback on the theory that the 418 Forward Brewery, 418 4th Street to the north is a non-residential district, and therefore it's a 10-foot setback. But the ordinance speaks to the adjacent properties, and of course, the property on the west side is residential. That's where my clients reside and own. So we assert that there's a 20-foot setback as evidenced by the fact that there's residential property on the west side where the Protestants live. And then there's a debate as to whether the property on the south side is residential, commercial. We could go back and forth on that, but we don't need to reach that point because there's the property in the west is residential. There's a 20-foot setback. So for all those reasons, we would urge the board to find that the governing ordinance here requires a 20-foot setback from the northern boundary, not a 10-foot setback. And for those reasons, the applicant's plan, modified plan, does not provide a sufficient buffer because it's 10 feet, not 20. So for those reasons, we urge the board to disapprove the modified plan. Thank you.
Okay, Mr. Christoph.
And Mr. Chairman, I would note for the record that a 20-foot buffer has been provided from the parking surface to Mr. Nelson's client's residential properties to the west. That shows on the site plan, and it's scaled, I think, at 20-foot buffer yard. And with regard to the argument to the parking spaces to the north, I think in his memorandum, Mr. Nelson talked about the space that's outside of the confines of the 424 building. And I would note that, in fact, that's not a parking space. It's a backup space. Nonetheless, if you look at the landscape plan that accompanied the modified submittal, you'll note that that has been buffered to a degree of approximately 20 feet from the property line. With regard to these spaces depicted underneath of the proposed reconstruction of 424, I would note initially that the existing structure has 10 spaces proposed to be replaced by 9 spaces. And it is our position that those, while off-street parking spaces cannot be located in, while off-street parking spaces can be located in any yard, they're not permitted in a buffer yard. However, subparagraph 2166.050C distinguishes parking in enclosed structures from parking lots. Specifically, I'm quoting from 2666.050, B says, except as otherwise specified, off-street parking spaces may be located in any front, side, or rear yard. Enclosed buildings and carports containing off-street parking spaces are subject to applicable yard requirements. I would remind the board that the building at 424 has been deemed to be a deemed conforming use, which means that it can be reconstructed, can be altered, can be modified. The proposal is to reconstruct it in essentially the same configuration relative to at least parking underneath of it as the existing deemed conforming use. There is no side yard requirement in the B2 OCD district. So there's no required setback for that parking if it's in an enclosed structure. I would note, though, that in fact, the parking is proposed to be located, the actual spaces, approximately 13 feet from the side property line. And that side property line is, by the fact that the ZBA was granted for that, as well as for 424 4th Street, they are essentially non-residential districts as the code defines them. So if in fact there is a 10-foot setback, that setback has been met. Does it need to be buffered? Our position is it does not, because the building is deemed conforming. The one space, arguably, again, if it's a parking space that might need buffering, is proposed to be buffered by landscaping. I would note also that landscape buffer between in addition to the deemed conforming status of 424, a landscaped buffer would violate 2158.030E1 A, C, and D of the code, which are the sections which deal with the OCD overlay provisions. And I believe I read those to you at one of our previous hearings. I'm not going to read them to you again, but essentially they require maintenance of the spacing. New buildings shall promote existing spatial and visual qualities. All new structures, buildings shall have bulk massing, et cetera, similar to the other structures on the block face, et cetera. Our position being that even if the 424 building were not deemed conforming and somehow it was required to be moved to provide a buffered landscape, a landscape buffer, that it would violate the intent of the OCD overlay district. As I've indicated, and I don't want to repeat myself, but 424, 428 is a non-residential zoning district due to the ZBA extension. Same is true for 418 4th Street. So any buffer need only be 10 feet. That is provided, as I've indicated, in the northeast corner. I'd note also that the definition of landscape elements in the code includes walls and or any artificially constructed barrier. So a case could be made for the fact that the intervening building section of 424, in fact, does meet the definition of a landscape element. I think that's probably all I have to say on that point.
Mr. Braithwaite?
From the city briefly, I note that in the application, of course, the city says that this is a minor, it's a minor modification. The very letter from June 1 of 2020 that comes from Mr. Leo Wilson talked about the reason that they were trying to get themselves in between, and this is, it says C2 on it. So a letter that says C2 within the record is a June 1st, 2020 letter talking about the board's decision and why they needed this minor site approval. They talked about they needed to conform to the parking that was approved, and therefore this was their attempt to do so. Second, I look at C18, and C18 is our approval, and on, let's see. We note that in our approval, we noted that we were going to increase the rear yard buffer from 10 feet to 20 feet. We noted that we had increased the yard buffer to 10 feet next to 418. 4th Street for 430, we increased it from 4 feet to 20 feet. We reduced the total number of parking spaces from 26 to 23, and reduced the first floor restaurant seating from 41 seats to 31 seats. With this in mind, the director's decision that this was in fact a minor modification is entitled to deference. The fact that this application is not law of the case, because there's no case. So I'm not sure why there'll be law of the case applied here. On a separate distinct day, meaning June 1st, 2020, we were asked for about a minor site design modification, and we granted that request on August 25th. That is the law of the case. The law of the case is the exact record of which we have already provided the board in terms of the applicant's application and our decision thereon. That is the only law, in my opinion, that the board needs to be concerned with. And you can see that this process was not to get around anything that the board was doing, but is in fact to conform to the board's holdings. And as a result, I asked that the board uphold the city's city's decision. And I will ask that you uphold the city's decision, but also I don't think that it's fair to say that it's law of the case that that this project is somehow so final that it can't be changed anymore while we are having discussions about actively changing the process as we speak. With that, I'll rest.
Thank you, Mr. Braithwaite. Questions from the board?
Mr. Chairman, I have a question for Mr. Nelson. If I recall correctly, and please correct me if I'm wrong, the original variance that the board voted on was to the rear buffer yard. Is that correct?
That's partly correct, but incomplete. The complete answer is that the applicant applied for several variances, including variances in the rear closest to my client's property. And the applicant expressly also requested a variance for parking beneath the building. Then this is why I took the board through this chronology, because and this appeared, you see this request in the variance application filed on September 14, 2018. Then the staff report prior to the first variance special exception hearing summarized the requested variances at page 14, including the variances for these 9 spaces beneath the building. And then the board, in its opinion, at pages 1-2, addressed each of the 4 requested variances, including these 9. Then there was an appeal to circuit court, and the circuit court affirmed. So what this plan, this modified plan did, Dr. Shen, is to modify the plan in the back closest to my client's property. This plan addresses those, but ignores what happened with the 9 spaces beneath the building. And I would urge the board in its deliberations to pull up, it's in the record, the original plan. You'll see these same parking spaces. So this application is it's a how can you just disregard 2 years of litigation and a ruling by the board and the circuit court? I respectfully suggest that ruling by the circuit court is the law of the case that governs this case. So I wanted to make those points. Did that answer your question?
Yes, thank you very much. And I would like to hear Mr. Christoph, his response to your comments.
Madam Chen, Dr. Chen, excuse me. You'll recall that at the conclusion of the hearing, I asked for clarification from the chairman relative to the need for a variance to those 9 parking spaces. And the reason was, and as a matter of fact, in the variance application, it was set out that they were applied for in the event that, in fact, the board determined that they were necessary. And I'm looking at page 97 of the transcript. Mr. Christoph, in denying the variances, did the board conclude that the variances were necessary for the parking under the existing structure, which is deemed conforming and can be rebuilt? There are 9 spaces. Actually, I was wrong. There were 10 spaces, 9 now proposed. And the chair answered, the board considered which ones are you talking about? And I then referenced section 2166.050C, noting that enclosed buildings and carports could be contained, were subject to applicable yard requirements, not buffer yard requirements. And the chair answered, we didn't rule on that. So I then asked for, I said, you denied that? And he said, so the board has denied the application without further explanation. Ms. Rouse then, in trying to understand, and this is on page 99 and 100 of the transcript from that hearing, noted that she had difficulty understanding how the variances could be denied while the special exception was approved. And she said, the chair said, well, you'll have to work that out with them being the applicants. We denied the application for the variance. And Ms. Rouse said, okay, so potentially then they would have to redesign in order to get the use. Chairman Gallagher, you would know that better than I would. And that in fact is specifically what has been done. The site has been redesigned. There are no longer any variances needed. I think it's ludicrous for council to argue that because the variances that were necessary with that application, which the code says can be modified and has been modified and no longer requires variances, can't go forward before this board.
And so if applicant originally asked for the variances you're discussing, applicant believed it needed all of the variances in order to comply with the law?
Dr. Chen, as I've indicated to you, there was a question. And that one variance as to the 9 spaces along the northern side of the property was always presented in the alternative if determined as necessary. It was done out of, as I've phrased it, an abundance of caution, because if we'd left it off and the board came back later and said, well, you need a variance to this section, we'd have had to go through the process all over again. So the question was asked, the chair declined to answer it. You'll have to redesign, or you'll have to take up the planning and zoning to redesign. We submitted the modification request. Planning and zoning determined you don't need a variance to that section for the reasons I've already indicated. So we went forward with a modification. No variances are required in connection with this plan.
Thank you.
Mr. Chairman, may I respond briefly?
Yes,
Thank you.
yes, go ahead.
I don't recall an argument to the circuit court that the variance was argued in the alternative. There was an argument in support of that reversal of the variance ruling, and the circuit court ruled against the applicant. But let me address just the merits of the case. My reading of the ordinance requires a reference to 2 ordinances. The first is 21.66.050. This is the section with A through E, which talks about parking in the yards and enclosed buildings and carports. The board can read that ordinance itself, 21.66.050. I read it to mean this in the context of this case. The fact that a parking space is in a building or a carport doesn't excuse it from the fundamental setback requirements. That's what I take away from 21.66.050. Then I go to 21.22.110G, which talks about parking spaces with 16 or more spaces. And if it's adjacent to a non-residential zone, it's a 10-foot setback. If it's adjacent to a residential zone, it's a 20-foot setback. We assert that the applicant can't just pick one side, that this parking area is as a residential zone adjacent on the west side. So we assert there's a 20-foot setback. So for all those reasons, I respectfully urge the board to reverse the decision of the DPZ to approve the modified plan. Thank you.
Any other questions on this second issue from the board? All right, let's move on then to standing room, Mr. Nelson.
Thank you. We assert that DPZ erred by failing to address the parking requirements as a result of the standing capacity of the restaurant. But just to summarize, restaurants require off-street parking spaces equal in number to 30% of the seating. And for standing capacity in person. Standing capacity is computed as one person per 7 square feet in front of all counter and service areas. Now, when you look at DPZ's approval, they didn't consider the standing capacity of the restaurant. And we assert that was an error. We know from the record that there is going to be takeaway. Mr. Toomey testified, quote, "We will be doing some takeaway, but it, quote, won't exceed 10% of the sales." So then we look at the plan. We see the restaurant tables in the restaurant. We see a bar, and there's a position that the DPZ did not address the standing capacity, people coming in to pick up the takeaway. So we assert that that was an error. So for those reasons, we respectfully urge the court to reverse the DPC's approval of the modified plan and remand to that agency to address the standing requirements for the standing capacity. Thank you.
Mr. Christo?
Mr. Chairman, there is no requirement for providing parking spaces for carryout patrons. What the code says is that standing capacity is computed along with seating for one person per 7 square feet in front of all counter and service areas. What is proposed here is a bar, and you've put it up on the screen, and you will see that the bar is completely surrounded by, I think there are 11, I can't count them at that scale, but for which have been counted in the seating capacity. There is no counter or service area where one could stand, and even if one could, there's no requirement that there be a space provided for carryout. If you're going to argue that standing capacity, people could stand behind the seats at the bar, how deep would you have to go? One per 11 seats, 2 per 11 seats, and go back into the body of the restaurant? Do you double count? Do you triple count? I don't think that's justified when it's apparent from the plan that there is no standing capacity at that bar. And it's, again, illogical to think that for carryout, people are going to come up to the second floor. Obviously, if the 10% that Mr. Toomey alluded to come in to pick up an order, it's going to be waiting for them at the first floor. And the theory is obviously with carryout, and I think Ms. Rouse responded to this, the only time that they apply a carryout standard for parking is for restaurants that are primarily carryout, not one that by admission may do 10% or less of its business as that. Ultimately, I guess if the board really believes that this is an issue, and if the hinged bar where the bartender section goes in and out of the bar provides a place for someone to come and stand and pick up carryout, I guess you could remove one seat from the bar so that there would only be 10 seats at the bar and room for a patron to stand and pick up carryout from the bar. So again, the site plan does not show carryout. The site plan shows no ability to have standing capacity around the bar. So the calculation, which includes the seats at the bar, adequately addresses the code requirement for parking.
All right, Mr. Braithwaite?
Nothing further from the city.
Thank you. Questions from the board? No?
None for me, Bob.
Okay. Mr. Nelson, anything that you've neglected?
I think I've covered it. I just rely on 21.66.120, which talks about standing capacity is computed as 1 person per 7 square feet in front of all counter and service areas. The plan shows a counter and service area, and Mr. Toomey has said they'll be doing takeaway not to exceed 10% of their sales.
Okay, let's move on then to your 4th item, which also relates back to the 9 parking spaces.
The proposal in this modified plan is 65-seat restaurant, 4 residential units, which would require 23 spaces to fulfill the parking requirements. It's my client's legal position that the 9 parking spaces beneath the building are not allowed. 1, for 2 reasons. 1, the court's already ruled on it, and 2, they don't meet the requirements of the ordinance. And if you take those 9 out, 23 minus 9 is 14, but they have 14 legal parking spaces with this plan. And since they require 23, the proposed restaurant size is legally impermissible. So for all those reasons, we urge the board to disapprove, or we urge the board to reverse DPZ's approval of the modified plan. Thank you.
What is the legal point here that's different from your discussion under the 2nd issue?
It's similar. I was trying just to put a fine point on it, which is if you lose those 9 spaces, you can't have a 65-seat restaurant and 4 residential units. That's the point I'm trying to make here.
To respond to that.
Mr. Chairman, I think you're correct. It has been previously addressed. I didn't hear anything new in Mr. Nelson's argument, for the sole reason that that building is deemed conforming with the parking under it, responds to the contention that those spaces can't be there. They can be there. They've been there. There were 10 spaces there before.
Mr. Braithwaite, anything from you?
Nothing further from the city.
Okay, well then let's get on to item 5, the bulk regulations.
Thank you, Mr. Chairman. We direct the board to 21.50.150 for the, these are the bulk regulations for the B2 district, which call for a 20-foot transitional yard in the rear of the lot that coincides with the rear lot in adjacent residential district. So this is relevant in the context of this case because the rear lot abuts the my client's residence to the west. And this bulk regulation calls for a 30-foot transitional yard, and this plan provides for a 20-foot transitional yard, and therefore this plan does not conform with 21.50.150. And for those reasons, we urge the board to reverse the decision of the DPZ. Thank you.
All right, Mr. Christoph.
Mr. Chairman, I'd refer the board to table note 2 to 21.50.150, which says, in addition to required yards, transitional yards may be required as set forth in the following table. May, as the board is aware, is permissive, it's not mandatory. So they may be provided. In this case, the approved site design plan apparently was, according to planning and zoning, happy with the 20 feet. And I suggest that there's a good reason for that, because there's no need here for an additional 10 feet. First of all, there's a 20-foot landscaped rear yard. Secondly, by one of the board's conditions, the last 4 spaces, that is those closest to, 2 on each side, closest to the 20-foot rear yard, can only be used for residential purposes. I believe that's condition number 8 in the board's decision. Also, I would note to you that the property line between the properties is fenced. It's landscaped on the Protestant side as well. And the residences for which arguably that 30-foot transition was may be imposed are 60 to 65 feet from that rear property line and separated from it by two large two-story intervening garages. So the purpose for a transitional yard is obviated in this situation, and in any event, it need not be applied. It may only be applied. And to repeat myself here, there's absolutely no reason for it.
Mr. Braithwaite?
From the city, I note that the Director of Planning and Zoning had previously approved this. I would rely on the department's expertise in reading and apply, administering this section of the city code, and will argue that they're entitled to deference. So if we decided to do it, it's allowable by the law, as long as it's not a clear error. And we don't believe that this record shows any clear error on behalf of the board of the department. Thank you.
Thank you. Let's see. Questions from the board on the transition yard issue?
No.
No? Anything you need to add, Mr. Nelson?
Yes, I'll be very brief. My adversary has really argued that it's discretionary, and I disagree with that. But that's a reason for the agency to put in writing its rationale. If the agency is going to make a finding that they don't need to apply this bulk regulation in the circumstances of this case, I assert that the agency is obligated to put in writing why they reached that conclusion. Here, the record is silent in that regard. So for all those reasons, I would urge the board to disapprove, or I would urge the board to reverse the DPZ's approval of this modified plan. Thank you.
Okay. Last chance for any questions from board members. Okay. Argument is closed then, and the hearing on this will be continued to June 16th for deliberations. This is fairly complicated. I think I would like to have from each of the parties some fairly basic proposed findings of fact and conclusions of law. And if we could have those by, say, the 14th, that would give you 2 weeks to do that and give us 2 days to look at them before we deliberate. So what day is the 14th? Let's see.
I think,
In addition to being Flag Day,
Yeah. And well,
Monday, I believe, isn't it?
2 weeks. It's 2 weeks from yesterday.
yeah, so that's a Monday. And if you don't get them into COB, that gives us 1 day to look at them.
Could we make the deadline Friday, please?
Yeah, can we make it Friday at noon, the 11th at noon?
And if you wanted to have them in earlier, that would be acceptable also.
All right. Thank you, counsel, in the appeal. You may be excused. Is there any other business to come before the board tonight? No. Is there an ultimate motion?
I move to adjourn.
Second.
All in favor?
Aye.
Thank you. Thank you, Jackie, Cynthia, Sally, Tammy, Julian. All right.
Thank you.